Scroll.
Original side mentioned.
Original side mentioning. Come
But may I, with the lordship's leave, my lord,
Yes.
yes, my lord, may I, with the lordship's leave, mention this matter for filing, my lord. Leave is required. I'll indicate why. Because two orders, my lord, one passed by this honorable court and one passed by the honorable Supreme Court, has not been notarized. Those are the only two orders which have, those are the only two documents which have not been notarized. So I'm seeking your lordship's leave to file it, and subsequently, my lord.
Why not notarized?
My lord, the rest of it has been completely notarized. These two have been missed. This is, my lord, this has come from, this has been notarized in New Delhi, but these two documents have been missed out. But these two, my lord, are orders of the court. These are not any other documents.
File it.
Great.
My lords, with leave, my lords, may I mention in matter connected with item 10 and 11. My lord, there were three contempts that your lordship was hearing, one of which was dismissed by judgment of 13th March, on which we had sought for recall, and your lordships had issued notice on our application for recall for them to file affidavits within 3 weeks. My lord, the 3 weeks period expired yesterday, so we filed a can yesterday, hopefully to come up today, to declare as closed the right to file a
3
reply.
weeks expired yesterday.
Yes, my lords. Or arguably today, my lord, yesterday or today. It was the 11th April order. So we filed that can, my lord. It was processed by the registry and sent to the court. But apparently we omitted to take leave, my lords, for filing. I was not aware that we were required to take leave. So your lordship may kindly have it on board today, my lord, because that has a bearing on item 10 and 11.
Let us see if the file has come, then we'll see. Let us see. And so far as that matter is concerned, I have already dictated. I could not correct it. I think I will deliver on Thursday.
Very well, my lord.
I have dictated it. Complete. No difficulty. Yes. Yes, call the list. Appellate side.
Appellate side, item number 1.
I'm led by Mr. Shudipto Shorkar. The link has just gone anyway.
The files. Have the files now? See if I mind out.
What is this matter? Application?
My lord, in essence, we
Your
filed-
preliminary objection, this also will involve the issue of court fee.
I'm coming to that, my lord.
Appeals from decrees.
My lord, if I may refresh your lordship's memory, on the last date of hearing, all these three matters had come up. One had been converted into an FA. The other two remained FMA, keeping in mind section 105 of the CPC. These FMAs, my lord, have been filed.
These are the orders passed, disposing of the suit, rejection of the suit,
Rejecting the plaint.
My lord, it is
rejecting the plaint.
Rejecting the
but it
plaint.
is a composite order.
There is a Supreme Court judgment I could lay hand to very recently, which says no, it's a appeal under section 96.
May I have the reference, my lord, if we can try to distinguish it?
Hey, আমার খাতাটা আবার চলে গেছে।
It's the appeal from a decree.
I will give the reference. Supreme Court has said it's a decree. And
No, I'm not
96.
on the point, my lord, that rejection
so
of plaint
once
is a
it is a
decree.
decree, then the question of court fee will also come in. And the classification has to be done in this regard.
May I respectfully submit, my lords?
Yes.
I am not differing with the proposition that rejection of plaint is a deemed decree
Not deemed decree.
It is a decree.
That's the main thing.
or even a decree. I'm not on that point.
It's
My
a
lord, I'm not
decree.
on that point. My lord, my point is slightly different. My point, my lords, is that I have been subjected to an
In consequences thereof, the plaint of the such and such is hereby rejected.
my lords, I am on the point that I have been subjected to an indivisible composite order. And my direct principal primary grievance, as opposed to my indirect secondary grievance, is that I am an impleader, co-plaintiff, where notice was issued on my impleadment application. And then,
No, these kind of a situations we have faced when I was on that side of the room. What the Calcutta High Court procedure is that what we used to do is that we used to take out an appeal as well as a revisional application together and then seek a leave so that both can be placed before a bench. There is no difficulty on the part of the Chief Justice to do it. It is invariably done. We have done it in the past also. When there is some kind of a confusion that what would happen, that a portion of the order is an appellable and a portion of the order is a revisable and both are indivisible.
Wow.
So in that event, it is assigned to one bench. So the bench really decides both the issues. So this is what is the normal procedure we used to adopt. That's the age-old practice of the Calcutta High Court. Just to avoid.
my lord, very well. My lord, I'll bear that in mind, my lord. I have a second argument, my lord.
Only
subject-
one thing, the impleadment application was never decided because the suit was dismissed. Well, there was no question. So, well, the question of preferring an appeal against the impleadment order, well, till the suit, my lord, is restored, if at all it is restored, does not arise.
Sometimes I do not know in this matter, but there are certain cases, suppose the
I followed you,
hypothetical
Lord.
cases
I
where
followed you.
where the court proceeded to dismiss the suit on the ground of non-joinder of the necessary parties.
That's it.
An application for impleadment of the necessary party is also pending without deciding that and then rejection. So in those situations that may arise, I do not know. In this matter, I am not talking about this matter.
I
But
followed you.
it's not a universal rule that you can't. There are situations where you can. So we have to consider here, it is a rejection, you have to.
My lord, may I just try my second argument? Because
An impleadment, then another problem is order 43 in a commercial site.
no, I'll deal with that, my lord. But the consequence of not dealing with my impleadment was also to deny me interim relief, and therefore I get covered under Order 43. My second argument, my lord.
No. Impleadment denied and impediment not considered and denial of the interim order. No. Never. Too far proposition.
May
No,
I
we
give a
can't.
more direct nexus, my lord? My lord, this is a
Convert it, no problem. And there is no fetter. I do not know. 1051 is in your favor.
my lord,
Section 105.
my lord, may I just try my last argument and then I will convert. My lord, is my respectful submission that the impugn order is a nullity in law. Therefore, Kiran Singh versus Chairman Paswan AR 90.
CWN, SC says Supreme Court, no problem.
Yes, ma'am. So in a nullity, my lords, I can challenge in any class of proceedings,
Anywhere,
anywhere,
any
at any
court,
time, at any time,
any forum.
at any forum. My
Oh,
lord, may I
the
read?
appeal is a creature of a statute. If the statute does not provide a remedy by way of an appeal, nobody can presume or assume the existence of such remedy unless it is expressly provided. Can't do it.
Let me argue.
Can't do it.
Let me argue against myself, my lords. Suppose in another appeal to which I am party, someone else challenged some other order. And in support of his argument, he presents this order as well. My lord, I just want, because I'm
I
very clear
understood.
about what I'm saying.
No, I understood. Yes.
So in that appeal, I have the right to raise a collateral attack on this order, though it is not the direct subject matter of that appeal. So if that be so, my lord, if I have the right to attack this order when it is simply used in an appeal, could it be said that I, as the appellant, am barred from filing an appeal against that order against which I have the right to challenge as a collateral attack in another appeal? My lord, I think that would be a slightly
I have an answer. I have an answer. Don't worry, I have an answer to this. So that is the different situations. Even at the executing stage, you can go and say that this order is a nullity. Under section 47 also you can raise. Even you can raise in a validly constituted proceedings that this order is a nullity. There is a different, these are all the different situations when it arises. When you yourself is coming and assailing a particular order, which per se appears that it is not maintainable, then in non-maintainable proceedings, can that plea be taken?
It's my respectful submission, my lord. It's
That
my
is what
respect.
is it? It must be a validly instituted proceeding.
My lord, I'll
If
answer
it is
that, my
not,
lord.
then
My lord,
you convert it for this fringe issues. We don't think so that we should dilate more on that. You convert it, there is no difficulty because definitely the appeal lies against an
So
order.
I convert it into an FA or a revision, my lord,
FA.
and file a revision.
It is up to you. I have
I-
indicated 1051 as well.
So I just quote, I've already quoted
So-
105 in this matter by a new can that was filed yesterday. So would that suffice, my lord, for your lordship's
And don't convert us into advisory jurisdiction.
ex debito just
No.
not advisory? my
No,
lord.
no.
I,
It is, we can't say it is valid or
I
it
would
is
be
not
seeking
valid.
your lordship's advice for another court.
No.
But if I'm appearing before your lordship's court, it is not advice from your lordship. It is simply your lordship.
Thing is, we will consider, you come, we will definitely consider what is required to be done in this. The present appeal has been registered, has been
Fantastic.
classified as first miscellaneous appeal.
Your lord, my lords are
So
granting
the
leave to
order
appeal, my lord.
under challenge, in our opinion, is a decree within the meaning thereof under order 2 within bracket 2 of the codicil procedure. By the impugned order, the plaint has been rejected, and therefore it is a decree which is to be classified as first appeal. So the office is directed to reclassify the appeal from FMA T to FAT. The liberty is granted. The limitation has expired, no, or it has,
It was filed within limitation, my lord.
no. By this time, the limitation has expired
No, my
on
lord, because certified copy was
19-1. And the certified copy was
27th April, my lord. We applied on 20th March. We got it on 27th April, my lord.
Where is sorry, we'll get it here. There's nothing. Oh, this is, where is the calculation made?
My lord, I'll give the certified copy, my lord.
Where is the
it seems-
certificate copy?
My lord, we taken leave to file without certified copy, but
Oh.
we'd applied for it. But I have the certified copy now. I will just show it to your
Give
lordship.
it to us. Give it to us.
But your lordship may note, my lord, 19th January order, certified copy was applied on 20th of March. That was within the limitation. And certified
20th
copy.
March, 60 days.
Yes, my lord. So it was applied within 60 days. And we got it on 27th April. In the meanwhile,
Absolutely on the last day. If the calculation goes on, it's on the 60th day you applied. And when the appeal was filed after the certified copy was made ready,
Lordship has a certified copy.
23rd March, 22nd March.
First page. The dates are on the first page. Lordship.
April. No, I don't.
I'm sorry.
I am groomed in this jurisdiction, sir. I know. It was on 27th of April. Oh, 17th March, second at 20th of March. Which order? 19-1. Two different certified copies applied.
Beg pardon?
Two different certified.
My lord, we
certified
applied
copies.
actually for 5 appellants, my lords.
One was taken out on 17th. One was taken out on 28th.
Proxy litigations, we applied for 5 appellants.
We were appearing for all 5, my lords.
It's not necessary. Even if we take this one, that's the 17th, it is well within.
That's
well
all.
within.
I'm not on the limited. I'm saying, my lord,
It was
5, my
pretty-
lord.
So limitation.
No, I'm sorry, 4 we applied, my lord, and all 4 FMATs have been filed. So my learned friend may review his choice of words of proxy litigation.
The deficit court fee shall be put in by, what is the date? When you going, by tomorrow?
Yes, my lord, or we'll file section 149, my lords.
No, by tomorrow you can.
By tomorrow, or we'll move the application under section 149. Either way, my lords.
We can grant you a time. You tell us, you want 1 more, 2 days, 3 days, we can. There's no difficulty, sir.
Only listen to them, my friend.
We are exercising that
By next Tuesday, my lord, we'll file it.
the deficit court fee shall be put in by. What is the date? Next Tuesday?
9th of May, my lord.
9th.
Ninth.
9th is a holiday. You can't put it.
Oh,
9th is a holiday. I believe so. 9th is a holiday.
8th May, my lord. Monday we'll do it, my lord.
By 8th. May. Or we can give you a 10th May.
Very well.
Don't regret. 10th May, 2023. Which is a certified copy applied by the appellant here?
May I just come back to your lordships, my lord, before your lordships rise? I will give the details because there are
No,
different
I will
appeals.
not rise.
No, my lord, there are different FMAT, so we have to correlate which was applied for which FMAT. I apologize, my lord, we should have done that homework before we came. I'll do it.
Let the certified copy of the impugned order filed today be tagged with the memorandum of appeal. Tell your clerk to stitch after ascertaining.
Yes.
Give it back. Hitaao diye dao Firoz.
126.
Let them ascertain. Yes, call the,
124.
the second is the same.
Same.
Same, my lord.
Same order.
The same order may be passed in item numbers 2 and 4.
4 is applying.
Oh,
3 is a different one.
3 is different.
In
3
4,
is a different.
we have
1
some
and 2, 1 and
submissions.
2, my lord, for the timing. Your lordship will kind of say 1 and 2.
Regarding 4, we'll make some submissions, Lordship.
3. All 3.
Item number 3.
Hey, Walter now. There are 2 appeals. There is an appeal by my learned friend Miller. When Miller, the trial court. Oh, there was, it was sent to.
No, the parties couldn't agree, Millard. I got little upset, Millard, that day. Millard, trademark infringement suit
Let us
filed
see.
before the Rajarhat Commercial Court. No order was granted. Subsequently, Millard, order was on appeal. From refusal, an order of injunction was granted.
So before my
The
lordship
mark in
proceeds,
questions,
my lordship proceeds with the application, so may I have my lord's leave to file the certified copy of the orders with
Yes.
the certified copy? We have taken leave to file the appeal without the certified copy of the orders.
Hetu to ito.
They are ready, Millard.
61 to.
May I have my lord's leave to file the certified copy?
What was the date of the order?
The date of the impugned order was.
Impugned order, Millard. I have it, Millard. Lordship, gives me a moment. 5th of April, Millard. 5th of April, Millard. Gives
No,
me
not the.
No, 5th of April, this court
31st
passed an
March.
order
31st March.
March 2023, Millard.
and When the leave was granted,
The leave was granted on 4th April. We had no, we had first, but we had mentioned the matter, sought for leave, and then we had moved the application. But even the requisites were Will you kindly have a look at the memo of the leave?
why you did not file it on 5th? What constrained you not to file the certified copy on 5th
I
when
was-
the matter was moved?
That the advocate record mentions that they have obtained it later. By the time the appeal was moved, in the second half is what he's mentioning.
Trademark, Harish, or Bulletin would be, trademark these issues, commercial would be, contracted these issues.
On 4th April. The 4th April, it's mentioned here.
It was applied on 4th, notified, requisites notified on 4th, deposited on 4th, made ready on 4th, delivered on 4th.
Yes, we got.
Then why on 5th it was not given to the court? You had the certified copy in your possession on 4th. And when you can get a certified copy in a day, that what was a hurry in seeking a leave and then filing it on 4th? I find.
We were not quite aware that we would have gotten Monday because there was some difficulty with the department. It so happened that we got it on Monday.
The leave was sought on 4th.
Yes, on 4th in the morning, the
Oh.
leave was sought.
Yes.
And while we had sought for the leave, we had applied for the copy. But we had also not. We were not quite sure of getting the copy of the very same day. Mr. Chaudhary is leading me.
Why you did not file the certified copy on 5th when you obtained the interim order?
Listen, when we had got we filed it with the
We obtained leave to file without.
But you got the certified copy on 4th.
Yes.
When you moved on 5th, you were in possession of the certified
you
copy.
are. It has to be. No, I'm
So?
sorry. Milord. It is required to be filed immediately after you obtain it. Especially when there is leave granted for filing.
Have they filed reply?
No, my lord.
Opposition?
Milord, we have filed a vacating application, Milord.
Have you filed your reply
Well,
or
I want to file.
opposition?
Milord,
Have to
I am opposing, Milord, the continuation of the order. Why, Milord, I say, Milord, if Lordship permits me, Milord. Milord, suit is
No,
premised.
I can file, my lord, today being a Tuesday, I can file by
Milord, this
Friday.
order, Milord, should go, Milord. Gross
No, there
suppression,
is
Milord.
no urgency.
There is
Reason
absolute urgency, Milord. May
There
I
is
get my
another
chance?
order in another suit which we have
Very
obtained,
unfortunate,
from
Milord.
which they have filed an appeal.
Yes.
That's also before your lordship. My lord, until that order is vacated, he can't really ask for vacating.
Milord, I'll
this
show,
order.
Milord, I'll show, Milord, this order on his plane can't go. Milord, my learned friend has a label mark, Milord, in respect of class 30, which is, Milord, not for cakes and confectionaries. He comes and shows the court that particular mark and gets an injunction, Milord, on, Milord, dealing with this particular mark. Milord, that order, kindly look at the malafide. That
I'm
order,
sorry, I
Milord,
must
absolutely,
indicate-
absolutely. Milord,
I'm
kindly look
sorry.
at the malafide.
Very
Milord, that
clearly
order, Milord, clearly states that order will not come in the way of running, Milord, the defendant, Milord, the business of cakes and pastry. Milord, that order is not shown, Milord, to the, whatever, Milord, the interpretation is, Milord, the plaintiff goes again back to the, Milord, Rajharat Commercial Code and gets an order. The plaintiff cannot carry on business dealing in cakes and pastries.
Absolutely.
Where is that earlier order?
Millard, kindly Millard takes Millard my vacating application. Kindly have a look at it, Millard.
Then
Which
in
one?
that case, let me move my appeal, my lord.
No, he has to first move it, the
Yes.
vacating application.
Yes, I have to move the vacating first. Kindly Millard have my vacating application, Millard, can 3.
Yes.
Kindly Millard takes page 17.
1-7.
1-7, Millard, 17.
Yes.
May I please, Millard? Millard, trial court refused to grant an order.
No, I have seen the order. I have seen that.
Take Millard, page 17.
Yes, I have seen that. I have read.
This is an appeal. This appeal is arising out of an order passed by the judge commercial court, such and such on an application under order 39. This is a passing of action. So Millard, learned judge says it's a passing of action. The suit was filed by the plaintiff primarily on the ground the plaintiff is the prior owner of the Mark Creams. The company is carrying on business from 2001. Within a short span of time has gotten substantial because of the quality of the product. So Millard, passing of action 2020-21, user 1 year. User Millard 1 year. It is stated that the revenue earned for the financial year 2021-2022 was rupees 4 crores and odd, and the plaintiff has claimed that his product gained immense popularity and is a well-recognized and well-loved household brand among the people of West Bengal. In view of the continuous and uninterrupted and extensive use of the trademark creams, cakes and more and trade creams celebrating the life, the plaintiff company has acquired an enormous goodwill and reputation and synonymous. These are label marks. Now, Millard kindly takes the next page. The plaintiff has also filed an application for registration in the class 30. While checking the status of their pending trademark application, the device creams and more, the plaintiff came across an application pending for registration of the device creams, bearing the device look with a deceptive similar to the plaintiff's trademark schemes and bakes. Well, this is happening, Millard, much prior thereto. Before the learned commercial court, it was contended on behalf of the plaintiff that the adoption of the device creams and cakes and bakes bearing the same bold font as used by the company for the registered trademarks as cream celebrating the life and creams, cakes and more, which the plaintiff is the prior user and constitutes infringement of copyright owned by the plaintiff in relation to artistic work comprised in the registered device mark, creams and celebrating the life, creams and more. So it's a copyright. So copyright means what, Millard? The two labels placed side by side should be, Millard, identical. Next, Mr. Such and such a learned counsel appearing for the appellant submits that the trial judge having accepted the plaintiff's appellant has been established a prima facie case balance of convenience and injury, has declined to grant an order of injunction and directed the matter to be placed after a fortnight upon notice to the respondents. It is submitted that if any prior notice is served on the respondent, the very purpose of application will be defeated. We have carefully read the order. It appears that the plaintiff has been able to establish a trinity for the test of getting ex parte order of injunction. Now, Millard, kindly take, Millard, the next page, and also arrived at the finding that the 3 principles of temporary injunction have been fulfilled. Once the court has come to a finding that the plaintiff has fulfilled the test as required for ex parte ad interim order of injunction, the court could not have refused its exercise of discretion in the court as the very purpose of the application of injunction would be defeated. If the protective order is not secured, the intellectual property rights of the plaintiff on the basis of the material available on record, the trial court could not have refused to exercise the discretion in favor of the plaintiff, and after having arrived at the finding the prima facie case in balance in favor. Having regard, this is similar to limited injunction passed. Having regard and regard to the facts and circumstances of the case, there shall be an ad interim order restraining respondents from using what? Cream celebrating the right. What Millard argued? Millard, cream celebrating the right and the creams, cakes and more in any manner whatsoever. That's the word mark. So Millard, the business name creams, bakes and cakes was not restrained. Now Millard, kindly take. Next is very important. Millard, this order is twisted to get an order. The order shall not prevent the respondent. That's Millard, the creams, bakes and cakes. Using any other device. So you use any other device in relation to its product other than forming the subject matter of the suit. Next, the order of injunction shall continue until further stay is directed to be served within 40
That is
days.
another thing.
Yes.
So what is the difficulty?
Millard kindly takes, Millard, what he has done. Millard, is strict principle, Millard, will not apply, Millard, of Millard, contents of the plain, true and correct, because the court here, Millard, has granted, Millard, an injunction on an appeal, Millard. Now, Millard, kindly have a look,
What?
Millard, on an appeal. This is a continuation. Now, Millard, kindly take. What is the difficulty? Difficulty is something else.
So they have said that you cannot use this particular mark, cream
Absolutely.
celebrating life and
Yes.
creams, cakes and more.
Yes,
But it does not say the cream, the creams, the cakes and the bakes or
Yes.
the bakes and cakes.
would be restricted.
It does not talk about those things
No.
because they say you can use any device, but not this terminology.
Yes, grateful. Now, my lord,
So-
one.
So what?
My lord,
Then what is the order ingredients of order 39 rule 4?
my lord,
tell us.
kindly, my lord, takes.
What is the ingredient of order 39?
Kindly, my lord, takes me, hears me for 1 minute.
Yes.
My lord, the plaintiff, this is a second appeal which is on board. He goes back, files a second suit and gets an order
Yes.
that this particular defendant cannot run the business of cakes with the know-how.
That is a
etc.,
different
etc.
issue.
No,
That's a different issue. We are on variation, vacation and setting aside
Yes.
the order under order 39 rule 4.
yes,
You know the language of order 39 rule 4. It is never intended to or
yes.
to find the erroneous findings which has been made. Never talked about
No,
that.
I'm coming on to that. Kindly bear
Never
with me.
talked about that. One thing is there has been a suppression of the gross suppression of the material facts. If the facts are not suppressed, if the facts have been suppressed, then all these situations can be gone into all these incidents under order 39 rule 4.
Yes, my lord, kindly, my lord, visualize the
Or
situation.
another one is a greater hardship is another
My lord,
concept.
what is the suppression? My lord, suppression is,
Yes.
kindly, my lord, bear with me.
No, we are bearing,
Yes,
but you'll have to answer the queries.
I'm answering the question.
Yes, please.
My lord, the plaintiff is the 50% shareholder. Our my lord, the
Have they
Aditya group.
suppressed this?
Yes,
They have suppressed
yes,
in the plaint?
yes, not stated.
Yes.
The defendant, my lord, which is run, my lord, by the Shah group, is
Yes.
50% shareholder, not stated in the plaint.
Yes.
My lord, the memorandum, my lord, doesn't have any negative covenant. That's not
Yes.
stated in the plaint.
Yes.
My lord, these are the grounds. Kindly have a look at the plaint now. Kindly have a look at the
Yes,
plaint.
we are looking at page 51. We
Yes,
have
kindly
directly
have a
gone
look at
there.
page 51.
Yes,
My lord,
show
lordship
us.
is much. No, 51 is the second plaint. Kindly do
Second
not-
plate. Okay.
don't look at it, my lord.
Yes.
The timing,
yes.
don't
We will
look at
not.
it. Kindly don't.
Come. Which one?
My
Tell
lord,
us.
kindly just gives me a moment, my lord. Plaint. This is, my lord, page 99. My lord.
Yes. Yes.
My lord, this is the subject plaint, my lord.
Yes.
My lord, first paragraph, the plaintiff was incorporated in 2001 to engage the bakery of confectionery.
No
carrying out-
difficulty.
No difficulty.
Correct.
Incorporation, no difficulty.
Correct.
Plaintiff is the owner of the registered device cream celebrating the life.
Yes.
Well, I pause here for 1 moment. If someone is a registered owner of a device, he cannot get billed on the strength of his registration.
That
right
is
over the
again a
word,
merit.
in the merit.
That is a merit. Again, you are on order 39 rule 4.
Yes, I'm billed order 39
Please,
rule 4.
please read that particular
I have
language. of order
read it.
Yes,
I have an
please.
appeal billed challenging it from
Yes,
billed.
yes.
The certificate of registration dated such and such, the plaintiff company comprises style K, etc., etc.
Yes.
Millard,
Yes.
this goes on. Millard, nowhere it is stated in the plaint.
Correct.
I, Millard, show the subject matter of the suit, which
Yes.
Millard, the learned Millard, Judge Millard says.
It is a company which is incorporated, has filed a suit.
Yes,
Now, if there is an authorization, if there is a decision
yes.
taken by the board of directors
Yes.
of the company to
Kindly
institute
come.
a suit,
Family
where is the difficulty? What
Kindly,
more
where is
is
the-
required? Shareholding pattern, everything is
Yes,
required to
kindly
be
take
clear.
Millard. Dipankar Dotto. Millard, kindly take page 122.
Yes.
Constituted attorney. Where is the board resolution?
Which
Who is
one?
the board? Page 122.
Go there.
Millard, where is the Millard,
Say-
the case?
say-
Where is the case?
Say
Millard,
that.
kindly take. Millard, now Millard, the plaint proceeds. Here, Millard, it's not a question of I am coming up with the ex parte Millard identity
Yes.
order and challenging. It's a
Yes.
question division bench, the order granted by the division bench.
Yes.
Millard, I am applying here, Millard, for non-extension of the order, Millard. Millard, that's the case. It's not a case, Millard. The Rajarat court has granted the ex parte order. I am for that.
Yes.
Rajarat court refused. Division bench grants the order.
Yes.
Millard, revision bench passes a limited order. So, Millard, whether that order could have been passed on the facts shown. If it was moved on notice.
Yes.
Millard, kindly look at his plaint. The plaint proceeds. Millard, I could have understood very well, Millard. I could have understood.
Wait. Let me find out. Don't worry. Don't. Yes, there is a resolution. They have annexed with the copy. Yes, so
But
there
now,
must
Mr.
be, there is a presumption is that there may be a resolution so far as the filing of the suit is concerned.
Yes.
Otherwise, Castron mining.
Ah,
Oh,
please, you did not have to. When I know the Castron mining matter was at one point of time argued by me also. I appeared.
I remember.
Yes. So don't say this is what it comes. So
my lord, kindly look.
if the
my lord.
company has taken a wrong
Lord, the
resolution,
company-
go
not a
and
question,
order
my lord.
39 rule 4 for the injunction.
My lord, I have
Well,
filed a vacating. Why? The vacating is before this court.
Yes.
Vacating is before this court.
True.
I am, my lord, arguing on whether I'll be permitted to argue on merits. Because I have not filed, this can be treated as my opposition. Then I can argue on merits on
That
the
is
injunction.
that is what when you insisted, I
Yes.
just wanted when you said we are a 50% shareholding.
Yes,
So I was just under that impression that vacating application when you have taken out, let
Yes.
us see whether that has any bearing on this. And if it appears that the resolution has been given of the board of directors, I do
Yes.
not know whether you were present or you were not present. We
Yes.
don't know. This is a question to be decided on trial. Everything is to be gone into at this stage, whether the court will vacate the interim order
Yes.
on such suppression,
yes.
which is of so it is of so it is of so high magnitude.
Kindly visualize the
This
situation.
is,
Kindly
this is what is
visualize.
to be done.
Millard, kindly visualize the situation. Millard, the company is the owner. Company is run by Millard two persons, two groups.
If
One owner Millard is 50%, other is 50%.
I do not know whether company when it comes, it's a single entity.
Yes,
I do not
correct.
know whether company can run by segregating there with the on the basis of a shareholding
Millard,
pattern.
then I go to the very basics.
So
Let us Millard go to the basics
yes,
on the merits of the matter. Kindly take the merits of the matter.
again I am saying you are under order 39 rule 4.
Lordship can treat this as my vacating and hear out on merits.
Then they have an opportunity to file a reply because they are entitled to respond to your allegations.
And
Are
let
they
the
not?
matter appear on Thursday, Millard, because
Yes,
Millard,
let them file
my
their-
business is,
I was contemplating that. From the very first, I was
I
contemplating.
must show Lordship one
But
thing.
The moment you started as usual, in a usual manner, I
Yes.
just thought there is a gross illegality
Gross
that has been
Millard,
done.
Lordship,
But
sir,
I find
gross.
that you are really impinging upon not only the findings recorded by the court, you are impinging upon something
Kindly
more
Millard, have a look.
which does not come under order 39 rule
I'm
4.
Grateful, Millard. Kindly,
So-
Millard, if
So
Millard,
it's better let them file a reply. If you say that your vacating has to be treated as an opposition to a
Not only that.
injunction, no difficulty. They have a right to
difficulty,
file a
Millard, this is
reply.
the next matter, which is Millard, I have filed it.
Yes.
This is not in the list today, Millard. It's of a second suit.
That is what is a very important thing.
Yes, and the
That
second
pending
suit,
one, how they have separated or segregated the cause of
and
action.
Millard, they got
One
an
has to
injunction,
understand.
which Millard which was basically given a leverage by Millard, the division.
It's true.
Gets the same order.
After hearing the respondent, after hearing the respondent, who has filed an application for vacation, variation, and or setting aside the order, setting aside the ex parte ad interim order passed on 5th for 2023, submits that there has been a gross separation of the material facts. If would have been shown in the plaint, may not invite the ex parte ad interim order of injunction to be passed in the instant appeal. However, during the course of the hearing, it is submitted that the vacating application may be treated as an opposition to an application for injunction, and the entire matter can be disposed of on merit. In view of the above, the vacating application is treated as an opposition to injunction application. With the rider that the strict principles of the pleading may not be available to the appellate. Full stop. Appellant is provided an opportunity to file reply to the vacating application, which is now being treated as an opposition to the application for injunction by Monday or Wednesday.
Lord,
Matter to be listed on Thursday.
Thursday.
This next Wednesday.
There's a other appeal, my lord, let it appear on
Let it
Thursday.
appear together.
No, my lord, I am not. That, my lord, he suppressed with the order, my lord. Can't be, my lord.
Very well, let it appear tomorrow. I have no difficulty.
Yes. Difficulty, my
Give
lord.
the name, it will appear tomorrow.
What?
We will be concentrating whether that interim order could
That
have been
interim
passed
order, my
or
lord,
not.
is in
That's
breach
all.
of the division bench order or not.
Yes, yes.
Yes, I'll, my lord, show, my lord, how the gross the suppression is.
Give the name, it will appear. It's called
The third.
I don't know, 4.
Milord, may it appear tomorrow, Milord, in that case. May it appear tomorrow.
which one?
The other appeal, Milord. Because Thursday it will come in the afternoon, which I wanted to avoid, Milord. If it
No, Thursday. We can't.
Thursday afternoon.
Whatever. I do not know.
Very
Afternoon or before noon, I do not know.
Difficulty. Anyway, Milord, we'll make arrangement.
Yes, call the 4.
Number 4.
I don't know, 4.
Lordship, in this matter, Lordship had directed the deficit court fees to be deposited by first May, Lordship. Lordship, till now it has not been deposited. Lordship, I'm praying for extension of the time, Lordship, to file the deficit court fees, Lordship.
Why, sir?
Lordship kindly extends for some days, Lordship, so that we can file, Lordship.
When?
1 week, Lordship. Within this week? Within this week, Lordship.
Be sure that will be a last extension. Tell us take no time, we will extend it.
Lordship grants me 2 weeks then, Lordship.
It is submitted by the learned advocate for the appellant that because of an unforeseen circumstances, the deficit court fee could not be put in within the extended time. However, he prays for an further extension of time to put in the deficit court fee. Considering the above fact, we extend the time to put in deficit court fee by 2 weeks from date. List the matter accordingly.
Lordship, I appear for the trustee, Lordship. Copy has not been served upon me, Lordship.
Give an email,
Will serve.
give sir.
Will serve.
Give an email.
Appearance will be reach. Lordship, regarding the rest of the things, in having regard to the kind of appeal, Lordship, I was praying for some directions, Lordship, regarding paper books and bringing.
First, get over the court fee affairs. It is still born appeal unless the court fees is paid. We will not. I lost on that side before the division bench. So don't do that. Put it, come back. We'll give a directions. No difficulty. Call the next.
I don't know, 5.
He's placing in on Monday, Lordship. Next.
You asked for 2 weeks time to put in
Oh,
the
I'm sorry,
deficit court
sorry.
fee.
We have
So
to
we
come
have
back after 2
granted
weeks.
you
I'm
2
sorry.
weeks time.
Yes,
No
you have to come back
difficulty.
after. I'm grateful. Lordship.
Malos, but if I remember correctly, subject to correction, if I remember correctly, they had said this very thing, that until you pay the court fee, nothing will happen.
Sorry,
Your Lordship
they
said
have
no.
nothing to say so far as the court fee is concerned. The court fee is a matter between an appellant and the court. If the court feels that the court fee is to be paid, even they object, we will not hear them.
No.
EIR 1961 Supreme Court, if I am not wrong,
Well, I'm only
does
on
not
the-
say so. It's the
I-
court fee is a matter between a court and the. Yes. Call the next bit. Other matters be taken. Yes.
Item number 5. I'm the appellant with it. I was making my submissions. My notes are on record. Let's say whether it's a commercial dispute, B. Millard, I had argued.
Because the difficulty is because we have been grappling with lot of the
Millard,
the
only
judgment
one
matters we
difficulty
have
I
been
face.
giving every day. We are giving two judgments.
Millard, Millard, have the
So,
difficulty again. 10,
Before,
the order
before
will be
vacation.
extended.
Before
Millard,
vacation.
I am enjoying, I am Millard restrained by an order of
Before
injunction.
vacation.
Millard, Millard, again I have to
We
come
can
back.
fix a date. Or
Millard,
all agree. We have been now giving us suggestions. All these contested hearing matters, if you can come on Saturdays, argue, 2 matters have been fixed. The lawyers have agreed.
Millard, I am agreeable.
Agreed.
Millard, I am agreeable.
Last time, the Saturday, one bench sat, they argued. No difficulty.
Millard, I am agreeable, Millard.
Yes, Saturday.
Lord,
So that there will not be any
Lordship,
hurry. Matter is called in another court, something of that kind will not come.
Lordship, the difficulty is
Millard, only
none of my seniors or whoever will be present because everybody is doing it pro bono. So
Millard, I am for suffering an order of injunction.
Pro bono, why?
Because Millard,
no,
two of the members of the bar Millard are also Millard.
What?
2 of the members of the bar Millard, they are also
What? Which one?
Tata, Millard.
in the Tata matter.
2 members of the bar. You never.
no, it is
disclose
not
that.
named. It's not named. It's not.
They are not the petitioner.
They are not the petition.
They are not the petitioner, Millard.
Their rights are Millard.
They are
What
not the
rights?
petitioner.
No, Lordship.
They are not the petitioner, Millard. It shouldn't be.
No,
taken.
no. Then who are they?
Lordship, they are not the petitioners. They are residents in the society. They are
They are residents of
No,
the
no.
society.
Which one?
Lordship, we are agreeable to do it before your Lordship. There is no difficulty at all.
I have
No,
a principles that I.
Lordship will take it from me. We have no difficulty at
No,
all.
I know, but. Who are they?
They are not,
not
parties,
parties,
Millard.
Lordship. They are not
Section 9,
parties.
they are not parties. They have not come up.
They are directly or indirectly affected by any adjudications made here.
No, Millard.
Who are they?
May not be.
Disclose the name.
Some
You
of
are an
them are
officer,
standing before your
you are
Lordship.
an
but
huh?
Some of them are standing before your Lordship. I cannot. But Lordship will not do that, Lordship. Look,
Lordship has heard out substantially this, but this point
Whatever,
Millard should have been
whatever.
taken. Millard.
Maybe
I am not
this
taking
thing
this
was
point.
never projected before me.
I'm not taking this point.
The petitioner.
I'm not
they are
taking
not
this
the
point.
petitioner.
Suddenly this came up,
Look, they
suddenly
are
this
not the
came up.
petitioner, not the respondent.
correct? Suddenly when it came up,
Millard, at the after Millard, I finished my hearing, notes are filed.
what
Millard, I give my consent, Millard.
I also give consent.
Both the parties giving consent, Millard. What's the difficulty, Millard?
But
Lordship has
I'll
heard-
tell you, Lordship, we do not have any problem whatsoever.
I know,
And they are not the petitioner, Millard.
I know.
Millard, if they are the petitioner, Millard, Lordship would have released it. They are not the petitioner, Millard, who has affirmed the petition. And we are only arguing on the point of law, that's all. And every court, this point will be there.
I'll be candid, Lordship. I am personally involved. He is involved, but we have no difficulty at all. We have no difficulty at all, Lordship. Yes. Uh, some more are there, Lordship. Some more are there, but I do not wish to name them.
The difficulty will be in all benches, Millard.
All benches.
All
Lordship will kindly keep it after vacation, Millard. Substantial arguments have been done, Millard. And we never took this point, neither Millard, my learned friend is-
It came up because of the fixing of Saturday, that's why.
Practically, the name which is appearing in the cost title never indicates.
Yes,
they are not parties. Arbitration is between Nilabjo Sarkar and Millard Tata. That's all.
The hearing, I have a very strong response in this. Knowingly, I will not. Unknowingly, something has happened because I must say that I have a very bad, the memory of memorizing the name of many of the persons. I may not recollect the name, but I know my face. So that may be a reason by name I may not, but the moment the face.
No, petitioner's name, my lord, he is not an advocate, my lord.
I know. But somebody must be claiming through him.
No, how, my lord? They are not, they have individual rights. They have individual rights.
They're putting an impetus. Now you came to know of that. Now you have come to.
No, my lord, I knew that because the petitioner was not, I did not, he also did not. We, my lord, because if he was the petitioner, I would have left the brief, my lord. Substantial, he heard, my lord, lordship will kindly record, it will be better, my lord, to get an assignment. Because all court tell
Matter was substantially heard. None of the councils before us disclose that some of the members of the bar has a direct or indirect interest in this in relation to.
Then lordship, I have to record something more because not only bar. It is not only bar.
This was. This
गलत हो
was
जाएगा।
disclosed for us.
गलत हो तो भूल हो ही जाएगा।
We proceeded to hear out the matter. But today has been diverse.
Huh?
That's. The
They want to
opposite
party
facts
with
are present.
That will be recorded.
Evidence should take in the instinct.
Lordship,
Should not be proper on our part to pick up this matter as. As the practicing advocate.
Lordship, may I simply release it?
Simple release, simple.
Because
Wanted the
no,
recording
I'll tell you, there will be more difficulty.
No, it was heard.
Wanted the recording of the submission.
Very well,
That
lordship.
we have to record our findings.
Very well, very well. Kindly will record.
Do not.
Simply will.
Release it on personal, that is all.
No, we were doing it, but he insisted.
I beseech your lordship, my lord, it will create even further complications, my lord.
Very well.
Lordship will kindly, my lord, release it on.
Because it's
personal,
not
that is
only-
all, my lord.
It's not.
Release.
সেখানেই problem.
That's my principle. I think it's very strong principle. And I frankly speaking, I expect from the member of the bar that the moment they know that this is my, they should.
But we had no difficulty, I'll tell you.
We have no
Lordship.
difficulty.
To know that I do not take up a civil court.
I know.
Everybody knows. They fairly comes and say this is alternative promise. I am really indebted to them that they have fairly come and said. I also expect from the members of the bar that this is also one of the principles.
That we did not know, my lord. Any member involved, lordship doesn't take up, my lord.
Never. I always said knowing it.
Then we also.
I'm not aware.
Even we were not aware that this thing is there, let's go. You were proceeding bona fide before your lordship.
But I know by face.
बोलेगा उचित होगा।
I expect that the members of the bar will definitely take this henceforth and will immediately tell. if there is any suspect.
Leave to pray for assignment, my lord. Lordship will give.
What leave? It is whatever, it will go to the honorable chief justice.
Very well.
Number 8. Sorry, Lordship, because this was never the intention, so we went on.
Maybe incidentally or accidentally this came.
In fact, we filed our notes also, my lord, on the last occasion. my lord.
Item number 8.
Lordship, item number 8, I appear on behalf of the respondents, your lordship.
নেই তো।
Lord, my lord, item number 8, my lord, I beg to appear, my lord, on behalf of the appellant. It will be my lord's kind pleasure to take it up, my lord, any other day, because this is a hearing matter and it'll take a little bit of time. Online, my lord, probably I will not be able to do justice. I have no problem.
Yes.
I appear on behalf of the respondents, Your Lordship. I'm also praying for not to.
Any Saturday? After the vacation?
Yes, my lord. I have no problem.
Can we fix it on 10th June?
My lord, this side
Lordship
of the
commits
vacation,
the
my lord, I
matter
have a
to
short
the
point for your lordship.
Your Lordship, on Thursday. Even Mr. Banerjee is on his legs, Your Lordship.
Because the
We let
hearing
Mr.
matter,
Banerjee
we
in the
wanted
matter.
now, we are shifting all the hearing matters on Saturday so that at one go, it goes and then immediately the matter can be disposed
Whatever
of.
Your Lordship pleases.
So the probable Saturday is the 10th of June.
But why suddenly on a Saturday, my lord?
Because
Yeah,
I find that
specific
all
concept.
these matters, they consume so much of time. And then the motions, everybody comes, there is an urgency, they are mentioning the matter. That's the whole problem which I face. And if you want to cut short the matters, the members of the bar will not allow us to decide it, because they will go on arguing day after day. They will not stop. So
Well,
it's better to do it on Saturday.
This matter, my lord, I can assure your lordship that I have a very small point with respect to, my lord, if an amendment application is pending, my lord, order 7, rule 11 should not have been taken up. When the amendment application.
You are sure that you will not argue more than 10 minutes? You will simply say this point and tell us
Yes,
and give the judgments.
yes,
Yes.
yes.
When tell us, we can finish it up before the vacation also.
Look, any day, my lord, next week on Monday, if your lordship pleases.
It's a commercial court matter.
Yes.
It has to be on Thursday next
Then Thursday, my lord, on 4th.
or a day after tomorrow.
Day after tomorrow, Your Lordship.
Day after tomorrow.
Absolutely.
On the prayer of the appearing counsels, let this matter be listed on Thursday.
Grateful, Judge.
Grateful, Your Lordship.
Extremely obliged, my lord.
Yes.
Item number 9.
I am appearing on behalf of the applicant.
What is this defect?
Defect, I have inquired into, there is a report of the stamp reporter, but the cost title has not been set forth in a proper manner.
So
But I have taken steps, my lord. I have deposited the corrected cost title. I have got the number and informed the stamp reporter office. But since the file is before your lordship, the final report could not. But I have
the defects have been pointed out by the stamp reporter. Which needs to be cured. It is submitted that they have taken steps, but because the file is lying in this court, the defects, the stamp reporter could not proceed. Stop. In view of the above, let this file be sent down to the stamp reporter for doing the needful.
My lord, the matter is required to be heard by your lordship. My lord.
You go, immediately it will go down. Lunch is so much so now.
So that the matter can be taken up on Thursday.
Correct. You go there, sir, and then it will list it on Thursday immediately. You get it done.
Not you, I am taking steps. I am taking steps.
You know, let the matter be listed on the next. That is a Thursday.
Okay.
Lunch is now. Let's call the next.
Item number 10.
My lord, I checked up regarding that mention I made this morning. The files are here, my lord, of CPAN 922 of 2022, in which your lordships had issued notice, my lord, on 11th of April for them to file a reply. Now, my lord, they've not filed a reply, but they have the time to file these 200-page applications, trying to scuttle the other proceedings that are pending before your lordships. So, your lordship, may please take a stern view, my lord, because as it is with the kind of pendency we have in our country, we cannot afford indulgence after indulgence after indulgence given to tardy litigants like this. If your lordship would recall, my lord, they wanted only 2 weeks. I mean, your lordship, I'm sorry, your lordship was granting 2 weeks. The learned senior counsel said, no, please grant me 3 weeks so I don't have to seek an extension.
Now,
So if your lordship could please, my lord, have that matter on board today. It's only a can to seek closure of the right.
Not listed today.
My lord, I think that's why I'm mentioning that your lordship may have it on board today. I think what my learned friend is stating is the obvious.
Yeah, 10 is 11 is CPAN 70 is been called on.
yes, this matter has been filed. Now, what is required in this matter?
My lord, in item
This
10.
is due to appear on some other day.
My
not
lord,
today
can my
also.
learned friend please allow me
No,
to
what
present
I
my
find
matter, my
from
lord?
the order of 9th of March, that the direction was passed in the matter to be listed after the judgment is delivered in CPN 922 of 2022, which has
Correct, which
already
has been delivered.
Delivered. So now, what remained here?
My lord, may I explain the what happened, my lord?
Now you have filed an application for
Recall of that judgment,
recall of that judgment.
where your
That
lordship,
is pending.
my lord, pending in the sense only from a hyper-technical point of view, in the sense that we quoted Article 215 for recall or correction of the order. And during the hearing last time, I filed a copy of the resolution plan for SR Steel, which is not on record of your lordship's court before. Your lordship verified on the 11th of April that indeed the phrase that there is an express provision in the plan that the pipeline belongs to SR Steel perhaps is not quite correct. And that impression was, let's say, prevailed upon your lordship at the instance of oral arguments by the other side. So since your lordship is prima facie satisfied that a false statement or a wrong statement or a
whatever-
incorrect presentation,
That matter has to be heard on merits.
I'm
because
coming to
That's
that. No,
true.
I'm,
No. I was just trying to, what shall we do with this matter? We are just thinking of.
your lordship may kindly issue notice allowing them to take whatever defenses or pleas they have in their reply. My lord,
No, the
please,
difficulty would be.
my lord, please see the
because-
conduct.
No, kindly visualize. This is a CPN against which order?
The same injunction as in the other CPAN which your lordship had dismissed. But this is a different petitioner.
No, that's true. But what is a sauce for a gander is a sauce for a goose.
So that is
It
correct.
is if the judgment which was complained of to have been violated, or the direction or the order which has been violated, and a contempt application at the behest of one of the party has come to an end. I
Not come
believe
to an end, my lord.
Yes.
Not come to an end.
come to an end means it is sought to be resuscitated by way of an application for clarification.
My lord, so
It
that is why I'm
it is
humbly
something
submitting. If your
it
lordship
has
just,
come to an end.
my lord, that is why I humbly submitted in the morning. If your lordship may kindly have that can on board today, which seeks closure of the right in the earlier CPAN,
Yes.
because that will have a bearing on this.
So there.
If
in
your
that
lordship closes
application, applications, the affidavits have been filed.
Not at all.
Lord, after going through your lordship's order,
Yes.
Lord, we find that your lordships have, Lord, dealt with it threadbare. So, Lord, we will only rely on your lordship's order insofar
sorry,
as the
my lord.
contempt application is concerned.
My lord,
I
this,
don't think, Lord, we can improve then what is,
So that application, you do not want to use any affidavits.
in that application, we don't want to use an affidavit, we want to rely on your lordship's order. And in insofar as these two contempt matters are concerned, also we want to rely on your lordship's order. And
my
that's
lord,
it.
so that
Because
is,
your lordship
my
has
lord,
dealt
so
with
that-
the matter threadbare.
So,
My lord, with
so that application has to be listed. Let us see, because the fallout of that application will have some kind of a bearing.
it may not, my lord, because,
will.
may I explain why? My lord, may I explain why?
Suppose the order is clarified.
May, no, my lord, if I may make my presentation, my lord.
Yes.
To hear CPAN 70, the argument would be that is barred by res judicata.
CPAN, the principle of res judicata would apply in a contempt jurisdiction.
My lord, in the sense that a matter being agitated has been settled previously in another matter. That's what I mean. But the moment that judgment is relied upon, 13th of March, our contention will be to your lordship to please ignore that because it's a nullity obtained by fraud.
Let us be.
I'm glad, my lord, that fraud on the court evokes laughter.
Sir, sir.
I don't think our country can descend
Please,
depths
please, that is-
shallower than that.
Please, that is the difficulty. Unless the court arrived at the situation that it is a nullity, one cannot may say that it is nullity, but the court has to may ultimately come to a conclusion it is not a nullity.
May I respond to
So
that?
this is what it all depends upon, an adjudication to be made in that application where
My lord,
you say that it is a nullity.
my lord, I had given your lordship judgments in the past.
Whatever. So that
No,
has been
that no
considered. So let
declaration
us-
is required.
we have seen.
What is required is
What
in the
is
collateral
required
proce-
is that if a party perceived, kindly visualize, a party perceived a particular order to be a nullity, does it become a nullity? It is a court which has to see
Yes.
that it is a nullity.
So I'm coming to that, my
So
lord.
the declaration may not be necessary,
Exactly.
but an adjudication on a nullity is a very important aspect.
Absolutely.
So now that's why that application,
Here we
where
go.
you say that there has been a fraud upon the court and it is a nullity, has to be arrived at by the court. And unless that decision comes, I do not think that it would be proper to proceed in this matter.
I'll answer that, my lord. Your lordship has recounted the law perfectly. The only point where I was going to interject with respect, but the interjection was not necessary, was if your lordship continued that vein, the thread of logic, and said that therefore the finding must be made in that proceeding. The law is not that. Your lordship has not just the power, but the duty under Section 44 of the Evidence Act to deliver that finding in any proceeding. In any proceeding where that judgment contended by a party is contended to be a nullity, in that proceeding, your lordship can.
It's a dangerous trend or a dangerous proposition of law. Suppose an order which is there passed by the court and it is being relied by a party before the administrative quasi judicial authority.
There no, because they have no power. No, there they have no power.
Even a per incurium they cannot say.
Well,
I have delivered a judgment where the authority said it's per incurium. I said you have no business to say it's per incurium.
Absolutely, my lord.
It's only the court. Now the question is that whether it's a nullity, forum clause, which forum, omnibus forum, anywhere you can impinge it's a nullity. Definitely one has to look into it in the perspective of the dispute or the cause of action or the nature of the litigations. One has to. So let that come. The situation.
My lord, may I make a humble request, my lord? Just please for a moment see it from our perspective.
Yes.
We are here alleging contempt.
True.
No,
That is
just
what
bear
is
with
a
me, my lord.
serious
My lord,
issue.
just see the past. I want to go back to the past. That CPAN, my lord, was filed in August 22. We visited Calcutta approximately 25 times in that matter. And all we were humbly urging was, whatever are the arguments, let them come on affidavit. For good reason or otherwise, my lord, your lordship passed a judgment. We sought recall. On their request, they were granted 3 weeks.
They
The
do
3
not
weeks.
want. Now they
No,
do
so
not want.
therefore, my lord, the law is that whatever has been asserted, they accept. My lord, I don't understand what's all this mocking nonsense going on.
No.
So if you're compelled
Don't
to
make
laugh,
a passing
please go
remark.
outside.
Mr. Counsel, you have just practiced. You have not acquired such, the excellence in that regard as of now. Respect the brotherhood, which the Calcutta High Court had the very greatest oppositions. Do not do that. Somebody may say you have a right to make your submissions, no doubt about it. But don't make a passing remarks in this regard. It's a demeaning the other brotherhood.
I apologize to my learned friend, my lord, if I'm arguing absolutely absurd things.
No.
But even Newton argued absurd things till the world realized.
We are live. I can't say, but there is one observation of Lord Atkins. So that could have been reminded in this regard. Anyhow, we are not going in this.
My lord, so my
What we feel is that definitely it is a contempt filed alleging an violation of an order or a judgment passed in the proceedings.
but on additional
Similar contempt
No,
application
I
was
beg to
filed.
differ, my lord. Not similar. Additional grounds, additional evidence has been uncovered.
Please. This similar application alleging the violation of the same order or a judgment was filed. That has been decided. Now, the moment that has been decided, one has to understand that what is the nature of the violation. I understand. The nature of the violation may be different for different parties.
No, here the evidence is additional.
The difficulty
There
is,
we
the
were not able to
difficulty would
convince.
be, then the explanation to section 11 will come into the play. If you could have taken that particular plea, having not taken,
No, these are additional evidence. My lord, may I explain?
can it be?
That CPAN was filed, I think, in August. Thereafter, many developments happened, my lord, in September, October, November, December, which constituted additional evidence of admission, not evidence of wrongdoing. My lord, please kindly consider my words.
That's why
Admission by them that they're in contempt. So they were packaged in CPAN 70.
So I think that application should be decided first. Let us see. Let us decide that application on Thursday. We are putting it because I know you people have to travel from outside frequently. So we respect it. So we can fix it on Thursday. If you can come, argue on that application in a limited manner. Show that which portion, according to you, is a nullity or a fraud upon a court. What has been done? As you have indicated, very small point, that it was not disclosed. It was not form part of the records. It was an oral submission. On that basis the court has. So you have disclosed that. This is what your contention in that application is. Let us see that application
Lord,
on Thursday.
if-
itself. Very small one.
Well, subject to correction, that is supposed to be listed after 10.
After
That was because, my lord, they wanted 3 weeks, I wanted 1 week. Very cleverly,
now
had they
you
said
do
it
not
that
want to
day.
file opposition.
No, my lord, whatever, my lord, today, my lord, the problem is we have made our plans accordingly, my lord. There are, my lord, I will not be there, my lord, on Thursday. So, my lord, whenever the matter was made returnable, let's
Made
get
a
it.
plan for one matter.
No, my lord, there are, my lord, normally, my lord, in these matters, I try to be, my lord, in town. It's not one matter.
My lord, since they are only relying on the judgment, I don't think, my lord, with
No, it
the
is not
utmost of
that,
respect,
but
that they
Thursday,
need
I
a
will
battery of
discuss-
counsels to keep on harping on the same judgment, my lords. They can marshal their defenses.
They have a right to say so. That right you can't take away. They have a right to make submissions.
No, I'm not saying they
So
can't. All I'm
they-
saying is, my lord, that since they're not.
Which day is convenient? Tell me. We'll fix that matter. We do not want to keep the matter pending.
11th April, your lordship fixed it, my lord, after 4 weeks. That, my lord, will be after 10th April, 10th May.
11th May.
Well, by your lordship's order of 11th April, your lordships fixed it after 4 weeks. That will be, my lord, 10th May or thereafter.
My lord, could I humbly request, my lord, your lordship may kindly have it on board today? Your lordships do, my lord, accommodate from time to time.
In a different matters.
Let it be on the 11th.
Situation like this, because if it is something which was never listed, we get it listed immediately on that day and then do it. When there is a direction that it has to be listed on a particular date, preponing a date, then the lawyers have to be heard at that.
No, but they're here today, my lord. That's
That
why.
is what I'm saying.
So
Is what I'm saying.
how
But
can they claim prejudice that it was taken on board today? And besides, my lord, we served a can on them. The can that
Not there in the list today.
I know what he wanted, that by way of a supplementary causeless, let that application be also listed today.
No, but
because
that will create
we-
a lot of inconvenience for us because that supplementary list has not come as yet. And we are here in court. That brief is not here. Kindly fix it on next Thursday, the 11th of May. Take it up on that day. That's the date which is returnable. This matter is returnable on the 11th of May. Fix it on that day and take it up.
Over 2000 page annexes filed in the original proceeding.
He also did not serve any notice saying that he would insist on hearing of that matter today.
My lord, they were served with the can day before night.
And serving.
And the can was, it was said,
Not listed. These matters are not listed.
Come on, 11th, we'll share out.
my lord, then, but could I humbly request, my lord, because the 11th will be the second session. If your lordship may kindly permit it to be the first item on board, my lords. Otherwise, it may not never come up.
Is the second session or the first session? Original said Thursday te first na this is huh? So it is in the first session on Thursday.
Big Barma?
Huh? Oh, this is
Appellate side. This is on the appellate side.
second. Thursday
Second
te-
session, yes.
Second session and duty pora hai.
Second session.
Okay. So you want first matter, no difficulty.
It's a humble request, my lord,
No,
because
no,
otherwise.
always. I always, I would say the respect when the lawyers are ready to do the matters. And if they feel that it is a convenient, we are always ready.
So, my lord,
do-
along with that CPAN 922 of 2022, if your lordship may also kindly direct for purpose of clarity, FMAT 1310 of 2016, in also which there was an application filed and your lordship issued notice. That application sought enlargement on the lines of Bharat Coking Coal versus State of Bihar, that status quo, if required to be amplified, should be made clear that what is the status quo.
Mr.
And they've
Costa,
not filed
to
an
be-
affidavit.
To be very frank, there are a lot of litigations who are just waiting for their turn. If one matter is given a precedence all the time, which
No,
consumes the whole of the day,
I respect
I
that.
think it is an injustice
I agree.
to the other litigants who are
I-
waiting for their turn. So
I'm only saying, my lord,
we appreciate the sentiments one after another, do it,
my lord,
not do it because all these four matters will come, whole day is consumed.
my lord,
And the other litigants who are waiting, they will not get a
Take up
chance.
that 922.
please,
You
this
want
can't be done.
922 to be heard first? Take up
not,
922.
my lord, it's
We
a
will say that,
connected issue,
that
my
this
lord.
matter and the application would also be taken up, will be listed on that day. That's all. Nothing
Very
more than
very
that. Our attention is drawn to the order dated 9/3/2023 passed in the instant contempt application, wherein this court directed this matter to be listed after the judgment is delivered in CPN 922 of 2022. So the reason for passing the aforesaid order was that the instant content application and the other content application being CPN 922 of 2022 are filed alleging the violation of the self-same orders. Full stop. The judgment in CPN 922 of 2022 had already been delivered. And this content application had been listed in terms of the said directions. However, it is pointed out that an application seeking recalling clarification, no,
My lord,
recalling
recall or in the alternative clarification that where is it mentioned in the plan express
or
provision?
an alternative clarification of the judgment and order delivered in CPN 922 of 2022 had been taken out by the applicant therein, which had been directed to be listed on 11th May 2023. Stop. In view of the above, we feel that the instant content application should also be taken up immediately up after the aforesaid application filed in CPN 2922 or 2022 And therefore, let this matter be listed on 11th May 2023.
Much obliged.
To be let both the matters be taken up at the first.
All three matters.
All three matters, 922, item numbers 10 and 11.
No, not the 11th one.
Let these matters,
That's different.
let these matters be taken up
10, 11, দুটোরই উপরে order আছে।
at the first.
Milord, only one thing, Milord.
Milord, item 11 is different.
CPAN 70, Milord. I am appearing for the petition number 1, Milord. Milord, because our contention is, Milord, we have not authorized. But I'm
I
just
have-
pointing out because, Milord, later it is said that why did I not point out earlier? This, Milord, we have faced.
There's no difficulty. It
My lord.
will.
Only, Milord,
We
only-
remember, don't worry.
Absolutely.
And I know he will not take that.
No, Milord, we
Once
have
you
got
have
this.
said, he will not take that.
He
Deep
said
down.
even a notice yesterday, my lord. I mean,
Keep it.
we're putting it on record.
Yes.
We never try to hide anything. Well, item 11 is different, my lords. Item 11, my lords, is that until your lordship's judgment, my lord, I'll just take 3-4 minutes, my lord, there's nothing to argue really. This is a CPAN alleging contempt of the same order. However, until your lordship's judgment of 13th March remains intact, the view adopted by this honorable court is that this injunction provided for the pipeline to be part of SR Steel. If that be so, and today it is so, if that be so, any action taken by any party contrary to that view would be contempt. And now this contempt is for ArcelorMittal filing a resolution plan for Hon'ble, where they contended that the pipeline belongs to Hon'ble. Now, my lord, the same pipeline cannot concurrently, contemporaneously belong to two companies. If they are happy, my lord, but please note, they are happy with 13th March judgment. They have not challenged it. Therefore, in fact, they are relying on it, they're pressing it. Therefore, my lord, it is their stand that the pipeline, in terms of the injunction, was to be an asset of SR Steel. Very well. But then they filed a resolution plan for Hon'ble, saying that the pipeline belongs to Hon'ble. My lord, please see through this conduct. Your lordship's observation that one matter taking up the whole day is not on account of our inability to present facts in 5-8 minutes. It is on account of their conduct, and if I may say, is obstructive, constantly harping preliminary objection after preliminary objection when they can be taken in their reply. And if they succeed, if their reply on preliminary objection succeeds, we can be saddled with costs to compensate them. But we cannot take valuable court hours arguing preliminary objections to scuttle the main matter. So I humbly request, my lord, the issue is very short. Pipeline either belong to SR Steel by the injunction or it belong to Hon'ble.
What is your
I see paragraph 36 of my learned friend's application.
So, you see,
At page 66, running page 66. This talks about
just 1 minute? Yes, 30,
paragraph 36.
36 at page 30. No,
66.
67.
67.
Could be 66.
It is under the heading of recall of the judgment.
It's
This is
63.
67, page 67.
That means service copy doesn't tally with your lordship's copy. Very well. I mean, paragraph 36 must be the same paragraph.
I
Hopefully.
don't know.
But this, my lord, is entirely premised on, my lord, recall of your lordship's judgment in order of 13th March 2023. Can't you see? In the event that the recall application succeeds, and this honorable court is of the view that its injunction dated 22nd December 2016 meant option 1 above, the petitioners undertake to withdraw this contempt petition, as obviously this honorable court would have revised its opinion as to the meaning of its own injunction, whose sequitur would be that no contempt would lie if any of the respondents have acted on the premise of the pipeline.
No, which one you are reading?
I really don't know, Lord. Paragraph 36. That's why, Lord, I thought, Lord, this maybe we have not been served
don't
with the right
know.
copy.
my lord, para 36, he's reading 36 and 37, my lords.
No, we are reading only
Oh.
36.
36.
It starts with,
Does
it
not-
is also
no,
to be
it starts
stated
at
in
35, it starts at
transparency.
30.
That's para 35.
That's para 35.
That
in
is
our-
at paragraph 36.
Then Lord, one extra
The
para must have.
petitioners have sought recall of the judgment on the ground that it was obtained by fraud by the contender
there.
respondents in CPN,
Paragraph
pertaining
35.
that resolution plan for SPIL contained an express provision for the pipeline to be an asset of ESIL. When this was not the case, that recall application has been concurrently filed and is yet to come for hearing. Then, in the event the recall application succeed, that is paragraph 37.
I
But
see.
it's 36
And
in
this
all.
court is of the view that its injunction dated such and such mint option 1 above. What is that option 1?
Well, that's on a previous page. Your Lordship may kindly have.
That's at page 54. Para 8, page 54 in the copy that has been made available to us.
Yes, my lord. Page 55,
Option 1
para
is
9.
page 55, part of paragraph 9.
Yes, my lord.
Paragraph
Because
In
of the-
our copy, it's 8.
I understand the page numbers may be different, but how can the paragraphs be different? If under the
Must have
paragraph-
added
Lord,
some
I'll-
paragraph.
Yes, my lord. So,
service copy is
so,
not the same
so-
copy.
yes, my lord, but I am not obliged to serve them before the hearing, my lord. Just allow me to finish.
And that's.
But
the-
nonetheless, I can offer them my copy right
No,
now.
no, no.
My lord, with
This is not.
Only
how it
three
is.
Anyhow, let us see. Because of the absence of NOC from Hon'ble, lenders mandatorily required by clause 5 of the cancellation deed as evinced. Also is Hon'ble's breach of negative covenants in this. Undertake to withdraw this contempt petition as obviously.
no, my lord,
Lord, would you
they
like-
are resisting 13th
They-
March. My lord, when this matter was filed,
Lord, would your lordship kindly come to the prayer, page 78?
my lord, are all these their reply, my lords, or are they trying to scuttle issuance of notice? Because if notice, my lord, is what they're trying to scuttle, it's my respectful submission
Where
that
is
the
the
lordship may
question
be
of
pleased to
issuance of
proceed on
notice?
what I have stated. If
When
it
your
turns out to be
lordships have-
false, vexatious, malicious, mischievous, all that, my lord, consequences will follow. But we can't take up court hour after court hour and obstruct hearing of other matters because they have the privilege of audience to keep on harping on.
But
preliminary
it's not
objections.
us.
No, just 1 minute.
I don't know, Lord, whether the prayers are same. I kindly have a look at the prayer.
It started page
Page
78.
78, it starts.
No, acting suo motu under Article 215.
Yes, and all other enabling provisions or initiate proceedings for civil contempt. So of court against the contemner respondents requiring to show cause as to why the alleged contempt each of them should not be committed to prison, otherwise penalized, etc. For disobedience of the order dated 22nd December 2016. And then Lord, the other 2 orders, 30th
The
August.
same orders I have already indicated.
Already your lordship have dealt with on merits.
No.
I-
That is a different. That's the merit
The
of the
allegation is
application.
different, my lord.
That's the merit of the application. We will have to consider it because this application for recalling is to be heard.
Considered.
So that is what I was just thinking in that line, whether it has to be heard along with that or not.
Absolutely.
My lord,
It
it's
has
my-
to find
my
is
lord, it's
that
my
after
humble
this,
request.
if such being the position, let it also, because if
Very
the recalling comes, then we'll consider it on that.
My lord, with due respect, no, my lord, please hear me for a moment, my lord. I mean,
We
contempt
have
solely
been
cannot be
hearing you
treated.
for a
so-
pretty long time. All the time we heard you so patiently.
My lord, it's like
With
this.
this
Today,
at page
by
para 36, 37, you yourself have said in a recalling that there is something, because if the recall is done, then it will invite.
even
the
then
situation.
they're in contempt. I'll explain why. My lord, even if it is recalled, they're in contempt for acts alleged here because from 13th March till 2nd of May, they have acted on the premise that the pipeline belongs to SR Steel. So therefore, they're already in contempt.
Correct. We have already dealt with, because in our judgment, probably we have already indicated. And we have, if I correctly remember, we have said that this stand is somehow have been barricaded or some have been done in this fashion. Everything has been, I think that has been spelled out in those judgments. I have to remember what I have said. So
annexed,
these are,
my lord.
these are the things one has to understand, because this is also dependent upon that situations.
My lord, may I try, my lord?
Because
May I
the
try?
basic
Let us say,
question is, the injunction was not to deal with the properties.
may I respond, my lords? Your lordship's injunction was what it meant to different people. It meant something to the court, maybe something to them, something to us, whatever it is. So on 13th March onwards, it is their stand that your lordship's contention that the pipeline belongs to SR is not in contempt of the injunction, meaning the injunction means that the pipeline is to be SR. They're in contempt from that day onwards for taking that stand.
Lord has not decided the question of title of the.
I am not on whether they have decided title or not. My lord,
Paint it, my lord,
no,
as
no, no.
that.
My lord, then may I again try?
This is what happens in all these matters. That is the whole irony, because we wanted one day to be dedicated for all these litigations, because the other litigants are really waiting for that.
Lord, we will come back on 11th.
My lord,
As the
kindly
lordship said.
issue notice, let them come on affidavit. I am requesting this honorable court in the interest of his own dignity with folded hands,
This is not
that
a case
please
for
don't
instance,
entertain
what-
all
what-
these
what-
oral objections.
What it will emerge.
This is not a
Suppose
case
if
for
they
issuance
come,
of notice.
they
at all.
are.
Let dismiss him. My lord, he is right. Please dismiss my contempt petition. It is does not merit notice.
The
Matters over.
difficulty is merit has to be judged in that sense. So if we invite them, because the difficulty is, I tell you very frankly, because this contempt application has been taken out when? It's been taken out on 29th of March 2023.
Yes, my lord.
Correct. So 29th of March 2023 is the situation where one has to understand that what further contempt they have done.
From 13th March onwards,
Correct. What
they
contempt-
are in further contempt
correct.
for
Now-
taking the stand that the pipeline belongs to
Now,
SR,
If
but they have bid for it in hospital.
correct, we will definitely consider this aspect.
Order is not to deal with.
Now,
Take a
now,
stand
so
and
far
take
as your role with the court is concerned,
Contempt, not part
That's
of-
a
you are
part of
merely an informant to the court. You are not in an adversarial litigations.
I respect that.
You are informing the court that, look, your order and the majesty of the court has been tarnished by them in this fashion, and your order has been flouted, violated, and everything. Now it's a matter between a court with the contemners whether he has. Now the court will definitely consider all these aspects. We can direct them to disclose their stance. There is no difficulty, provided.
Please,
provided.
my lord, the normal practice, subject to correction by my lord's superior wisdom, the normal practice is that if I make out a prima facie case, even on falsehoods, notice is issued, they file the reply and affidavits, and then the matter is adjudicated.
Correct. Correct.
So, no cause of action, it warrants dismissal, all very well. I applaud their legal acumen.
Yes.
Let them come on affidavit. That's all I'm asking.
Official
My lord,
case.
all these arguments, all this time wasting of the court will vanish.
Yes,
My lord, last time they said they took 3 weeks to file affidavit. They had no intention of filing affidavit. They manipulated the lordship's court so that no order will be passed on that day.
manipulated.
That's what it is.
Taking direction means manipulation.
Mr. Khosla,
This is
My lord,
unprecedented.
You should
My lord,
be choosy. You should
very
be
well.
choosy.
I
about the
withdraw
words.
that word, my lord.
Everyone else
They-
should be
not.
taken up
Because
to
at
task,
least
whether if they
we
say
can
something but not Mr.
say in this regard
He's an exalted.
that
position.
he will
he's
go
got a-
by the
got a
rule
valid
of the
point, my
law.
lord.
We will go by the rule of the law. And so far as I am concerned, I always owe every brick of this institution, and I will not allow the institution to let it down by any means.
My lord, may I amend my
Have a
word? They
greatest of
obstructed the
traditions.
functioning of this court by taking a stand which they knew they did not intend to adhere to. Even
that
they
is
could have
what
informed us whenever it could not be that last night they decided that they would rely on the judgment.
we will
They
take-
could have informed
we
us
will- we
that,
will-
sir, we're not going to file any
we will
affidavit.
take note of that. You cannot presume.
My lord, is my
Silence sometimes tantamount to.
Firstly, my lord, let me apologize for that word. I meant obstructed. They tended to, their objective was to deflect the intended course of this honorable court onto another course. And they succeeded. My humble submission, my lord, I'm sorry if I'm reiterating, but this will be the last time I will say it. This contempt survives independent of your lordship recalling 13th March or dismissing 13th March. If your lordship dismissed 13th March, this contempt lies 10 on 10. And if your lordships recall 13th March, even then this contempt lies for the contemptuous actions taken between 13th March and the date of recall. Because from 13th March till date of recall, their stand is that the pipeline belongs to SR. Therefore, they're in contempt for filing a resolution plan for hospital. It's simple, my lord. It has to be one or the other. It cannot be both, and it cannot be none. It has to be one or the other. And please see my disclaimer, my lord, that para 32. Please see how transparent and fair I've been to the court. Especially, my lord, please see para 35, if I may read. This means that they accept their silence. They're accepting 13 March.
I must compliment that I never come across in my career as the lawyer there or as when I shifted from that side of the room to this side of the room, that a pleading contains a draft affidavit to be shown by the other side in which manner and in what form.
My lord,
I have never come across these kind of pleadings ever. That the opponent would suggest that what affidavit he should file.
let me put it this way, my lord. It is a filled out interrogatory.
That is a different.
My lord, it is just
it should be only in a question form. That please answer this.
What I mean,
Please
but in
answer
effect,
this.
it's a filled out
But
interrogatory.
an affidavit draft, I never come across ever that what is to be done. Never done. The pleading never recognizes that. Secondly, I was just looking at this.
We said, my lord, or with variants thereof.
You were talking about the Contemptuous Act number 1 and 2. So we have read paragraph 15. All these acts which appears to us is relatable to
Paragraph 50.
their action prior to 13/3/2023.
Number 1, 2, 3.
My lord, that is correct. But
So, and Contentious 2 also talks about the earlier one. It does not talk about a post
my lord,
13/3/2026.
the reason for that is I am required to state on affidavit that which is not known to the Honorable Court. Now your lordship knows that from 13th March 23, their stand is that your lordship judgment is absolutely correct. Meaning pipeline belongs to SR. Meaning injunction meant pipeline belongs to SR and therefore no contempt. Which means
Contempt is maintainable. Meaning contempt is not.
Please, my lord, he's right. My lord, he's right. Please pass an order of dismissal of the contempt petition. Matter over. No, I'm not withdrawing it. According to him, it's not maintainable. Please dismiss it.
No, we don't mind, but we have to do a judicial order, and the judicial order must be in accordance with law, not to be swayed by the sentiments of the councils.
Correct.
It is to be on a basis of a law. What I find is that all these acts have been done. We will definitely record an order, no doubt about it, and then we will say that this matter should also be listed on 11th of May.
The same thing, Milord. I'm sorry to interrupt, Milord. Petition number 1, Milord. I have an objection because we have not authorized filing of this petition. You kindly record it. Milord, we'll argue when the matter
No,
is
then
taken
then
up.
record my response as well, my lord.
Milord, because
I am
made for
accusing the Mr. Rajneesh Sharma.
Milord, I started argument. Milord, he may allow me to.
I'm sorry, I
I
thought you
only
finished.
pointed out, Milord, the petition number 1 is not authorized filing of this.
The instant contempt application has been taken out, alleging the willful and deliberate violation of the orders passed in a different proceedings by the division bench, which was also alleged to have been violated in CPN 922 of 2022. According to the petitioner, the instant contempt application has been taken out on an additional disclosure of the conduct of the parties and the facts discerned, and therefore have no bearing and or dependency on the decision taken by this court in CPN 922 of 2022. However, what is your good name?
That I am being led by Mr. Mitra, my lord. Lord, Aditya Kanodia, my lord. I am being led by Mr.
Kanoria with Mr. S.N. Mitro appeared and objects the maintainability of the contempt application at the behest of the petitioner, which is obviously represented by what is his good name? Who is the by Mr. Rohan S. Nandi and Mr. Kushla. We do not intend to go into such aspect and keep it open to be decided at a later stage of the proceedings. We had an occasion to peruse the amendments made in paragraph 15 onwards, wherefrom wherefrom it appears that the allegation as to the violation of the aforesaid orders relates to primarily relates to the conduct of the LS containers pre 13/3/2023 within bracket karo, the judgment disposing of CPN 922 of 2022. We further find the aforesaid pleadings gives a further impression in us that the submission of Mr. Khosla that it is founded upon an additional facts or a discovery of the facts subsequent to 13/3/2023 has to be first ascertained on the basis of the decision to be taken in an application seeking recall or alternatively clarification of the said judgment stroke order dated 13/3/2022. The aforesaid observation may get impetus from the amendments made in paragraph 36 to 38 of the instant content application. Stop. Since the said application seeking recall or alternatively clarification of an order dated 13/3/2023 passed in CPN 922 of 2022 is directed to be listed on 11th May 2023. This matter may also be listed on the said date. After this aforesaid application in the supplementary case.
Oh, let it be with those other matters. Lord.
Let the certified copy of this order be made available to the respective parties within 3 days from the date of an application on a priority basis. Even the platform. Yes.
My lord, let it stand with those matters, my lord, clubbed with those matters.
One after that.
Very good. Because I heard your lordship say after the supplementary list, so.
In the supplementary. list.
I-
After that application, I said. After that application, in the supplementary. Yes. Well, the next matter.
May I ask for one small indulgence?
My lord, on a separate note, my lord.
May I ask for one small indulgence?
Our
My
members
lord? Let
know
the
that
verified
it's on the
copies.
Commercial Courts Act. Is that still on the annual, my lord? or-
No,
Because the numbers are not tallying.
just 1 minute. To be very frank, we had a meeting. We directed this practice direction to be circulated amongst the members of the bar to have their opinion therefrom. I do not know whether this opinion has come. We have directed this the sitting of the committee on a, I think in this week or the next week. If their suggestion comes, we will direct the
May I-
notification.
May I just make one sentence, my lords? We've heard of medical tourism. The state of West Bengal can literally start legal tourism because this capping of court fees, my lord, is a big boon to the world of business. But if the Commercial Courts Act is not given adequate impetus, that dilutes the advantage available from the Court Fees Act. So if somehow matters under the Commercial Courts Act can be promoted, it may very well be a resurgence of companies coming back to Calcutta, registered office here, tax returns being filed here.
On that particular, the court fees aspect.
My lord?
The court fees aspect.
No, I'm saying, my lord, West Bengal has a huge advantage over other states from the point of view of business houses.
Correct.
Because here, to get legal redressal of your claims, grievances, damages, etc., your court fees are capped at 50,000 rupees.
In a commercial court, commercial.
They're capped, my lord. They're capped.
Cap? No.
Yes.
There is a cap?
Yes, my lord.
I am not aware.
So, my lord, if
Cap is the same. I think it is on a percentage basis.
no, but it's a percentage, but subject to a cap of 50,000, my lord. Like in Maharashtra, it's 1,50,000 or 3 lakhs. In Gujarat, it's 75,000. In Guwahati, it's 20,000. So if there's impetus given to the Commercial Courts Act, where the functioning is streamlined, the rules are framed which clarify a lot of issues.
I think hopefully that will come in a very short time. I do not know whether bar you have make any suggestions.
If we could have a copy, my lord, or is it on the website?
No, it is already there. It
On
is
the website?
already there.
No, so
Let us
West,
see, let us
West
see
Bengal
this
could
week.
literally start a campaign for
No.
legal
tourism.
inviting companies.
Say a 1 month or a half just before. Immediately I started doing all these things so that it can come. So if the bar suggests, there is no difficulty.
Because one measure in my lord's hand, my lord, would be to allow hearings more than twice a week for half a day each.
Can't be, because it should have been because I have been given a entire determination under Article 323A, 323B, both the Central Administrative Tribunal, State Administrative Tribunal, then the Land Reforms and Tenancy Tribunal, all West Bengal, then entire commercial courts, appeal under the Chartered Accountant Acts. So we have to give to all.
No, I agree, my lord. I'm simply saying that if West Bengal wants to cash in on this huge advantage under the Court Act by coupling
Definitely,
it
we will
fast
definitely,
disposal.
absolutely, we will just try to put it. And we have the able guidance of one of the very good seniors here.
Lord, Maharashtra has the highest income tax returns filed in the country only because the companies have the registered offices there. And I would say 60-70% of the companies having the registered offices there are companies that have migrated from West Bengal.
No comments.
They can be brought back, is all I'm trying to say.
I crave your
Not
lordship's
much, but-
indulgence in CPAN 434, the order your lordship just dictated. Since we saw that there's a dissonance in the copy served and the copy that was filed, can verified reading.
I believe what has happened is because in the PDF form, they have a number.
Matlab, let them just reserve
Have
the
a
actual copy.
page.
Matlab, that's all that we are
While
doing.
printing
Let
out.
them matlab, reserve the actual copy.
We will serve. My lord, my learned friend
that is
need
it.
not
Give,
even
give.
finish his request. We
Yes,
will serve.
yes, sir. Yes, where is Mr.?
He'll be in his mailbox before he reaches Delhi.
They were Mr. Saha and somebody else.
Much obliged, boss.
Yes, matlab, I was only making a
Sarkar
request
was also
for
there.
matlab, the verified copy.
Yes,
Yes, Mr. Sarkar is also here.
where is he? Is he appearing in this matter or other matter?
No, he is there, matlab. He is there. He is, I think,
No, he's not here. He's
appearing
neither
parcel
visible.
and
Mr. Sarkar was appearing in item
He is
11.
logged out. No, yes.
he is now appearing. He is there.
My lord, I was just not hearing Mr. Khosla, my lord, and the state of West Bengal, my lord. So I was just quietly, my lord, switched off my camera.
He's agreeing with you.
All, my lord, all people of West Bengal will agree, my lord, except Mr. Khosla, my lord, should be deputed to advise, my lord, the government of West Bengal as to what needs to be done.
Right.
We can't do it. Well, item number 12, my lord, lordship will pass the same order, my lord. That's item 11.
Item number 12, why?
11 and 12 are both, my lord, Mr. Khosla's applications.
10 and 11, my lord, sir.
No.
Or
It is
10, 11.
10 and 11 are the same.
Same order. I'm grateful.
Yes. Yes. Thank you. 12.
Much obliged.
Number 12, appearing for the respondent, Lordship.
Appellant
Lordship, we had passed an order here.
Manali Ali.
Yes, Lordship, they are taking recourse to Lordship. Will see, Lordship, kindly have a look at the order passed by the executing court. They are seeking time there, saying the appeal is pending. And
I'm being led by Miss Manali Ali, your lordship. She's not be able to come to the court today because of her ill health. She just.
But this is not expected because this matter is pending for a pretty long time. Every
Yes,
time the
yeah.
adjournment is
Please
sought.
have a look at the order, Lordship, what they have said. Before
This
the
one?
executing. Yes, yes, my lord.
17th April.
Yes, my lord.
What more, sir?
He walked down 10, 15 years back. I am
Sorry.
struggling for the money.
I understand your lordship, but
Yes, the matter is listed today. This was appearing since last many time or?
Yes,
say?
yes.
so your lordship, there was a stay up and as
The
far as
matter
I'm
has
aware.
been, the matter is appearing in the list for a pretty long time. But the hearing could not commence because of the adjournments having been sought.
Paper book filed after 1
Stop.
year.
Even the last occasion when this matter was called on, an adjournment was sought on behalf of the appellant. Today, it is submitted that the advocate on record is ill and has not attended the
She
court.
is the arguing counsel as well in this matter, your lordship.
Yeah, that is the way. Advocate on record is ill and has not,
She has not come to the court today.
she has not attended court. Though the court do not intend to adjourn the hearing of the appeal yet on a humanitarian ground, more particularly that the advocate on record, who is also an arguing counsel, is ill. When she can come?
Your lordship, she has said that she'll be able to come if the matter is kept next week, because she's not sure that if she'll be able to recover
As
by
requested,
this week.
let
Let
this
it be
matter
on
be listed.
Thursday, otherwise-
As requested, let this matter be listed on next, that
Next
is the
Tuesday.
Thursday week.
Next Tuesday.
Thursday.
Thursday, Lordship.
However, it is made clear that The pendency of the appeal shall not stand in the way of any other proceedings pending before the court.
Highly oblige your lordship.
Okay. Then, yes, you will be sitting at courtroom number 4 there from 2 p.m. Because there is a specially fixed matter there at 2. What is this original side matter? What is the original side matter? Who is appearing in the original side?
Your lordship, original side matter, I am for the appellant. I have been led by Mr. Jishnu Shah, your lordship, in this matter.
So you want adjournment?
No, your lordship, we
So
want to
do-
do the matter today.
Do it.
I appear for the appellant, my lord, very interesting question. That is all that I can tell you, lordship. My lord, may I just take 1 minute, my lord, of your lordship's time? My lord, without going into the records, my lord, what happened is, my lord, there was an arbitration proceeding commenced by my learned friend's client.
Yes.
That he was the claimant in the proceeding.
Yes.
My lord, I was, my lord, the respondent and counterclaimant. I filed a counterclaim. My lord, while the proceeding was going on, my learned friend's client's company went into, my lord, insolvency. So, my lord, section 14 moratorium provisions became applicable. As a result, I could not any longer pursue my counterclaim before the arbitrator. So the arbitration proceeded only in respect of my learned friend's claims. The arbitrator, my lord, returned an award in favor of my learned friend's client. I, my lord, in view of, my lord, the law laid down by the Supreme Court, my lord, had to take my claim before the resolution professional, who has the power to, my lord, verify and determine claims. My lord, today, my lord, after, my lord, the award is passed, I challenge the award under section 34. My learned friend takes out an execution application. In the execution application, there's a direction on me to, my lord, furnish security.
Not in the execution. In their 36.
But I'm sorry, my lord, I'm correct. My stand correct. There's a direction on me to furnish security as a condition for stay of operation of the award. My lord, today I, my lord, make an application for modification of the terms of security. After I make that application, my lord, then, my lord, I am informed by the resolution professional that, my lord, my entire claim, which I had made in the arbitration proceeding, is allowed by him. Now, my lord, today, that claim is in excess of the amount, my lord, for which my learned friend has got the award. I say then, my lord, then I am not required to furnish security and the award is no longer executable. Well, that is my contention.
Interesting point.
My lord, that, my lord, the learned judge has held against me. It is very interesting. I'm sure, my lord, you'll
Interesting
also-
point. So can you come there at 2?
Yes.
ওখানে দিয়ে দাও দুটোর সময়। Interesting point. I got the, what would have an interplay between these two?
My lord, 2 o'clock, my lord, will your lordship kindly take it up, my lord, tomorrow? Well, I'm in some difficulty at 2 o'clock.
Look at it. You say it's a very urgent.
No, they are
It
protected. They are
is an
protected. The
interesting
learned
point.
judge has given them for 15 days time to furnish the security.
No, well, that is why, my lord, I preferred an appeal.
No. And
I am the- I
I
am the
shall be
KMDA.
taking the, my lord,
I am, my
point
lord,
of
not running away
maintainability of
anywhere.
the appeal.
Not tomorrow.
Day after 2.
Then day after.
My lord, kindly then keep it on the 5th to chuti, na?
শুক্রবার শুক্রবার তো হয় না।
Friday is a holiday.
If it is, but then kindly keep it, my lord, next week, my lord.
Then 9th Tuesday is a holiday.
My lord, 8th.
8th is a Monday.
8th is a-
Monday.
Well, I'm in just difficulty, my lord.
There will be maybe a late sitting of the court
I see.
on Monday.
Yes, yes.
On Monday.
Very interesting.
না না, একদিন সোমবার অব্দি ওয়েট করবে।
Yes. What to do then?
Thursday week, my lord,
The week
they are
11th to come.
protected.
11th.
তাই তো?
Actually, line. Let this matter be listed on 11th of May.
And question of maintainability is kept open.
All questions, including maintainability of the instant appeal, is kept open. Are kept open.
Not this Thursday. Thursday week.
11.
11.
11 তারিখ। হ্যাঁ 11
নিচ্ছে নিচ্ছে